very good evening to you. I am Lisa Lord, and my special guest is the Minister of People Empowerment and Elder Affairs, the Honorable Kirk Humphrey. Minister, thank you for joining us on the program once again.
Thank you for having me. It's always a pleasure.
Indeed. Now, you seem to be somewhat in the hot seat over the new child protection bill, which is causing some level of confusion amongst some Barbadians. So we'll try to dissect the bill as much as we can this evening. It has 70 sections.
70.
We cannot get through every section, but the most pertinent sections we will try to dissect.
Okay.
In very general terms, what is the purpose of this bill and how does it compare to the old legislation?
Well, first of all, let me say thanks for allowing us to have this conversation. I do believe that there is a need to clarify some of the issues that I've heard being raised in the public. Some of them I'm grateful to hear, really, because the kind of conversation that I've heard has allowed us to look at the bill with a different perspective. So there is no conversation that I've heard that I haven't found to have some value, even the points that are a little bit left field. First of all, I think we have to appreciate, though, that the current legislation that guides child protection in Barbados is extremely old, and it is a patchwork. So you have, if you want to know about children's welfare, you have to run to about 3 or 4 different pieces of legislation. It was necessary for us to combine this legislation into one. I think it makes it more effective, it makes it more efficient, and it allows us to service the interests of children a lot better. The other point is that the current legislation is extremely old. In fact, the legislation is 120 years old in some cases. So we have legislation written in 1904 that guides child protection with some amendments. Legislation written in 1918 and the Child Care Board Act 1985. So it is clear that the legislation is also old and needed some amendment. And there was also a need for us to be able to do that. And then the society in which we live has changed, children have changed, and there's a need for us to have a wider conversation around child protection. The way we look at this legislation, Lisa, is that we've now modernized the legislation. We've put children at the center of the legislation. We've determined that their protection and the prevention and parental responsibility and partnerships and so on are very important to us being able to advance this work. I am convinced that this legislation offers by far more protection for children than the existing legislation does. I'm also convinced that this legislation allows us to interact with parents way more in a much more structured way than the old legislation. It also gives the court more options. So there are a number of benefits to this legislation. I am happy to be the one to have tabled it and so on. And I think the last point I would want to make on this, Lisa, is this. The Convention on the Rights of the Child, which Barbados ratified in 1990, and not last year, not year before, in 1990. When you ratify a international convention, one of the commitments is that you implement national law to reflect the fact that you have ratified the convention. And Barbados ratified it in 1990. We came in, of course there were several conversations between 1990 and now. Several conversations. I've just been through the file. I've seen what the last administration did. They've also had several conversations. But we made this legislation Barbadian-based. We looked at the issues in Barbados. What are the issues affecting children in this country? And we made it relevant to Barbados. And when we looked at the international commitments that we made certain decisions in our legislation. So the legislation allows us to do what we committed to do, but based on the realities of Barbados. Not based on the realities of any foreign entity, not based on the realities of any foreign country, based on the realities of Barbados. And if we stick to the legislation, as I hope we will during the course of this conversation, you will see that there is nothing in this bill that is even slightly pernicious, nothing that is damaging to children, and nothing that the average Barbadian parent should fear.
All right, so let's get to the bill, starting with Part 1, Section 5. We look at a child in need of care and protection. What are some of these situations that would arise that would cause a child to need care and protection?
Well, Lisa, I have worked at the Child Care Board. I was manager of the Child Care Board. I was manager there for 5 years. I've sat in board meetings and I've sat with social workers who have given me details about the things that they have seen in Barbados dealing with children. There have been a number of concerns that they've had over the years that we've tried to strengthen in our legislation. Now, Section 5 in our bill looks at a child that is in need of care and protection. And we go through a whole set of them. And just to be clear, I would commend the public and I would ask them to look at Section 5. because persons are saying all kinds of things that do not exist in this bill. But a child that is in need of care and protection basically suggests that a child has been harmed in one way or the other. The thing about care and protection is that, for example, and I know the definitions have troubled some people, and I must also tell you, because we are sending this bill to select committee, and select committee means we're going to have further conversation on the bill eventually, we are open to making changes where there's a need for clarity. And so I am not so tied to a position that if I see that there's a need to make a change, that we won't make the change. But our position has been this. In relation to the abuse, definitions of abuse that exist in this bill, if you consider what guides the current administration of the Child Care Board, we've always used these definitions. So you would hear the director report, there have been X amount of cases of child abuse. What are the definitions that you think we've been using? There have been so many cases of sexual or emotional abuse. Now, when you look at the definitions, anyone can pick up a phone, Google child abuse, see what they see. Pick up a phone, Google sexual abuse of children, emotional abuse of children. You will see the kind of definitions that we currently have in our bill. These are internationally accepted definitions, and the truth is, for the most part, the definitions that we've been using all along. So there's nothing new in that regard. When what happens is that if a child is deemed to be in need of care and protection, if somebody calls in or if something is seen, a teacher reports it, and as we go through the different ways it can be reported, then the Child Care Board is mandated to visit the household or to interact with that child. When they determine, and the Child Care Board will determine based on their own experience and the techniques that they use in social work, if this child is in need of care and protection. If they determine that the child is in need of care and protection, then there are a number of interventions. Lastly being, you'll go to court and maybe get a custody order if that is deemed to be necessary. But between the professionals and the court that will guide us, we then determine whether the child, notwithstanding what we say is a child in need of care and protection, whether this child needs a level of care and intervention that requires the intervention of the Child Protection Authority. So because someone says, oh, I've hit my child, then I have to go before the Child Protection Authority, that simply is not true. Because in Barbados, our laws allow a certain degree of hitting. That doesn't change in this act. If it is, however, that they have determined based on the frequency, the intensity, the harm, because ultimately it has to be that you harm the child, the harm done to the child, that this child is in need of care and protection based on the several points that we've listed, then and only then would the Child Care Board go on to do other things. But one of the very clear interventions is that the Child Care Board can visit, the Child Protection Authority, can visit and determine there's no need for anything further. So I don't think Barbadians have to worry so much about what are the issues under which a child would be brought into care, which is what most people are asking me. It is in relation to the fact that a child really has been harmed. Most Barbadian households would hardly have reason to interact with this bill, as most Barbadian households now hardly have any reason to interact with the Child Care Board bill, Child Care Board Act.
You mentioned lashes, but I'll come back to that a little
Please,
later.
no problem.
However, Section 7, still in Part 1, simply states the participation of a child. What does that mean?
Well, it doesn't simply state the participation of a child. Section 7 goes on to give great discussion on participation, right? It says a child shall be allowed to participate in the decisions that affect the life of that child. It also goes on to suggest that the parents must weigh in where it is a situation where the parents are actually acting in the best interest of the child. And, we like to say in Barbados, or we grew up in a world where children were to be seen and not heard. And, things have changed. Mm-hmm. I have children. I have a 3-year-old who is capable now of having conversations that my 18-year-old, when she was 3, was not capable of having. Things have changed. People have access to different technologies and a larger understanding. And so the question here is, and you've seen, enough movies, we've seen enough movies where, for example, a child is saying, I don't want to go with this person. Person forces the child to go with the person, something bad happens. You want to listen to the children. The act also goes on to talk about the maturity of the child. And if the child is mature enough to be able to give a level of interpretation with the cognitive understanding, to be able to give it. When I was at Child Care Board, the phrase age appropriate meant everything. So it will be an age-appropriate conversation to determine that the child is able to make a contribution. But it doesn't mean that the child's word is the last word. It does not mean that. It means that, like everything else, the child's word is taken into consideration. But then between the board, the Child Protection Authority, the judge, the court, then a decision is made. So it is a complex scenario. But then if you look at Section 7 in totality, when we say that a child is entitled to legal representation, and some people have asked me, what does that mean? You know, why does a child have to have its own legal representation? Well, not all children are 3. You know, some children are older. They may have a disagreement with the director. They may have a different position from the one that we are taking. And we're saying, look, if you think and you're cognitively able, you think you want to have your own attorney, well, the court has to provide somebody for you. And then you get to plead your own case, because children now have that level of understanding. What most people fear, and I'm just being real with you, what most people fear is that when you give a child that level of authority or autonomy, that you might be taking away the role of a parent. Sometimes, Lisa, and I'm sure we're going to get there, sometimes it is the very parent with whom
the issues,
the child has the issue.
Yeah.
And so we have to be aware of that as well.
And just to be clear, a child refers to anyone under the age of 18,
Anyone
because
under
people
18,
get
yes,
confused
yes.
that once you turn 16, you're no longer a minor,
Absolutely.
but you're still a child.
You're still a child. So anyone, the legislation is clear. That's the other thing. In the old legislation, some said a child referred to anyone up to the age of 16.
Yes.
And others said 18. There were different pieces of legislation.
But
Our
this is
legislation is very clear. In Barbados, a child refers to anyone under the age of 18 years old.
Part 2 of the bill focuses on administration, and you referenced it earlier. This will see the establishment of a Child Protection Authority. This will have a board and a director of child protection. Let's look at the authority.
I think this is very important. You know, let us try really to center this conversation on this. There are many people who've called me as minister, previously when I was a manager, when I was also at Maritime as minister, when I was director of social policy here, or director of constituency empowerment, or you see it on social media. I've reached out to the child care board and nothing has happened. You know, I've reached out to the child care board, I've said this, they didn't do nothing. And, you know, it gives the impression that the child care board, sometimes they believe in cases that it's not necessarily true, hasn't done anything. We've listed very clearly what the functions of this protection authority is. The first thing I should say is that there are not going to be 2 organizations, 2 agencies. The child care board will cease to exist when this legislation is passed. There will now be a child protection authority. The government's larger plan as well is to remove the nurseries currently under the child care board to the Ministry of Education, and to allow the child care board to assume this new identity with training and so on, to focus on child protection and treat the nurseries as a school or an institution ready for learning. But the education component of that goes to education. We focus now on child protection. And of course, when we focus on child protection, there are a number of things that are listed here. I'm happy that we've listed several. I mean, if you go to the legislation, I know you've been through it. If you go to the legislation, we go from letter A to letter V in relation to what the rules are and requirements for the authority. But a lot of these rules basically relate to what will the child care board do, child prevention authority do in cases where we know a child has been abused, or in cases where reports of abuse came to the office. And let's go through a few of them. For example, let's just go through a couple. The authority shall provide care, protection, and rehabilitation of a child. That is innocuous. Care, protection, and rehabilitation of a child. Protection is very important in this legislation. It suggests that in many cases, the children that come to us are in need of care, protection, and in many cases, rehabilitation, because a child that has been abused is often in need of additional resources. People see the child care board facilities for housing and think that it's only about housing. Many of these children need help. Many of these children need love and rehabilitation. The authority will then investigate a complaint or report made in relation to a child or the mistreatment of a child. That is also very important. So these are the things that I think is important, but I think this point is very important. The authority will promote and facilitate contact between a child and his parent, relative, friend, or other person connected with him unless it is not in the best interest of the child. So that the authority now has a responsibility to keep the child and its parent, its child and its closest person together if it is in the best interest of the child. And then the last point that I would wish to make in relation to this is because, there's so many points that I think that are important to this particular thing, is that we state as well that in determining what is in the best interest of the child, we look at the child's right to the enjoyment of family life. So that throughout the bill, and if you look very carefully in this section 7, there are many things that relate to keeping the child with his family, working with a parent. It even speaks to the willingness of a parent to work with the other parent in determining the best interest of the child, which should have a lot of benefits, I think, for fathers who often feel that they're disadvantaged. How willing is this parent to work with the other parent, and so on, in determining the best interest of the child. So we've listed them. They're very clear here. The other thing is that the reporting is also clear, so that currently people may report to the Child Care Board and do not know what steps follow. What I find interesting about this whole conversation is that I think people haven't looked at the Child Care Board Act, and that they're making conversations around this protection bill without looking at what currently exists. Now, and I will mention this very quickly. In the Child Care Board Act now, it mentions what parental rights are, which are very important. But it also says that those parental rights can be taken by the board if necessary. If you look at the the Prevention of Cruelty to Children Act, it says that a constable, if he sees a person abusing a child, a constable can make an arrest. If he has reason to believe that this child had been abused, he also can make an arrest. And then the court, if they believe that the person committed some crime, could then go on to do further things. But this current legislation is that punitive. We take out a lot of those things in this legislation. So the authority, yes, is clearer, but in relation to some of the things that currently exist that people probably don't understand, this is a lot fairer to everybody who's involved in this conversation.
In part 2 as well, the role of the minister is also outlined.
Well, I think the role of the minister is very important. We have a job to take the report to Parliament, essentially. As it stands now, the minister also has certain responsibilities under the legislation. A lot of these responsibilities, however, are not the responsibilities that a minister will exercise. We have responsibilities in matters of adoption and so on. Normally, when something comes from the Child Care Board, we assume that the necessary work has been done unless there is something that says otherwise. In relation to this bill, I have the board, first of all, has to send to the minister every year a report on all the things affecting children in Barbados, particularly the children in care. Once those reports come before me, I have a responsibility to take that report to Parliament. A report has to be laid in this legislation in Parliament every year. I'm sure you've seen that. Once that report is laid, then we discuss it and so on. And of course, that allows us to set policy, because ultimately, our minister sets policy, ultimately. So in the administration, the day-to-day administration and the work of the Child Protection Authority, I will never get involved. I've been in this ministry since I was 28 years old. I came to this ministry, Hamilton Lashley was the minister. I worked with Hamilton Lashley, had a very good relationship. Trevor Prescott had a very good relationship. Dr. Lowe had a very good relationship. Chris Sinclair, a good relationship. And Steve Blackett, a very good relationship. I've had a good relationship with all the ministers. And I can think of no minister who's ever really intervened in the issues of child protection in relation to the day-to-day administration. These matters are left primarily to the professionals. And it is a tradition that has existed and one that I believe will always stand tall in relation to how ministers relate to this act.
Well, part 3 of the bill, however, deals with interventions, reports, and investigations. Now, this part of the bill has been getting a lot of feedback. One section in particular is Section 24, which refers to mandatory reporting.
Section 24 is one of my favorite parts of this bill, and I will tell you why. It has been clear to me that there are some people, because of the responsibilities that they have, the role that they play in a child's life, come into contact with information that could make or break our children. This bill is about protecting children. The mandatory reporting protocols in what we call duty bearers in section 24 is very clear. It's not every and anybody who are going to be responsible for reporting. I was in my hometown in the Pine over the weekend, and some people came up to me. We had a very good conversation, and they were asking me, you know, does this mean that I have to be responsible for, you know, reporting this child abuse, or now I will get a penalty? The reality is that the average person, by law, is not mandated to report child abuse. I want to make that very clear. Mm-hmm. The average person, by law, is not mandated to report child abuse. The law lists a specific set of people, we refer to them as duty bearers, who in the course of their professional work may come into contact with child abuse. Allow me to go through them because this one is important.
Certainly.
It is a parent, obviously, because currently what exists now is that you may have a child who's been abused. You're asking the parent, because the child is in the house with the parent, what has happened here? You get no answer. Or, you know, something starts and then along the way it stops. You get no further information. Parents are now required to report child abuse. A medical practitioner, an administrator in a hospital, a school principal, a social worker, a law enforcement officer, an internet provider, because internet providers sometimes see more than we think they see. We also included a computer technician, because you take your computer to be repaired and you may leave a set of pictures on there with you doing things that are inappropriate to children, or videos or so on, and then that person is also required by law to report. Any person who provides healthcare, welfare, education are all required to report child abuse mandatorily. And any person who, by virtue of the nature of their work, gets that information. The other thing is this, very clearly again, the average Barbadian is not mandated to report child abuse here, but however, I would encourage them, if they know of instances where they believe a child is being abused, to report it. And that has been the way for a long time. We have to make sure that we keep those persons protected and that is confidential. But in relation to mandatory reporting, you know, people have also asked me, what happens if you get it wrong? The law is very clear. If you report child abuse under the mandatory arrangements and you did it in good faith, then there is no penalty for you under the Act at all. The Act is very clear. However, if it is that you have somehow maliciously reported child abuse, then there are penalties associated with it. Now, it's been the way of the government to not give jail time for persons who have committed offenses that are not criminal. And it's something in this bill that I think when we go to select committee, we're going to have to review. Because if we don't want to criminalize people who, you know, didn't report, but there will be civil penalties that are harsh. So we will have that conversation later on. I've already said, you know, this bill is not perfect, and it is still in the phase where we're making amendments to it. And we're going to go to select committee, and we're going to receive input from all across Barbados. And as necessary, we will make the amendments to the bill. I said from the start we were going to select committee. This is not new. But I also want to say, though, that if persons have information and they don't report it, then and only then do these penalties come into being. We also say that this relationship where they have to report does not do anything detrimental to their professional relationship. You know, whether it's lawyer-client privilege or doctor-client privilege, that this bill does not in any way violate that. So we give them also that comfort. But I think it's important.
Well, Minister, we're going to take a short break. Still a lot more to discuss. Stay with us. You're watching One on One.
As Barbadians prepare for the Atlantic hurricane season, here is some information about shelters. Shelters are listed in two categories. A Category 1 shelter may be used during a hurricane or other hazard event, while Category 2 shelters may be used if they are still in a reasonable condition after a hazard event or disaster. Persons are advised to make their way to shelters well in advance of a storm's arrival.
Welcome back as we continue our discussion with the Minister of People Empowerment and Elder Affairs, the Honorable Kirk Humphrey, and we try to dissect the Child Protection Bill. Minister, before the break, we were discussing mandatory reporting. Now, at Section 27 of the bill, we see provision for protection of persons who make reports, because nobody wants to make reports and then there will be repercussions.
Absolutely. So before I mention what those protections are, let me
Sure.
say that we've had meetings with the Barbados Association of Medical Practitioners, we've had meetings with the nurses, the Bar Association, the Evangelical Association, the Social Work Association. We've had several meetings. Police force, so that they understand what the law is going to be asking of them. Having said that, understanding is not enough, so we have made it very clear what the protections are. Section 27 is specific to mandatory reporting. This is what happens in relation to people who the law says have to report. So where a person makes a report under Section 24, it does not constitute a breach of any professional etiquette or ethics. That's the first thing. So like we're saying, you report this, you're not less of a professional. That's the first thing. There shall be no liability incurred for defamation as a consequence of the report. So these protections exist obviously to encourage people to come out and to report. I mean, we go through a whole lot of them. And then we conclude that this person is not compelled to be involved in any proceedings, unless, of course, it's determined by the judge. But he doesn't have to produce a report, a copy of his report, nothing. We protect the person who makes the mandatory report, and for obvious reasons. You know, there are many cases where a child might confess something to a teacher, and what we saw during COVID at the Child Care Board was that we saw the reports of child abuse go down, because schools are often not only a barometer by which you could gauge whether there have been increases in child abuse, but it's also one of the best points of intervention.
Yeah.
In many cases, because teachers can see a child who's traditionally been very active or strong, suddenly very quiet and withdrawn. Or a teacher can see bruises, or a child is limping that wasn't previously limping. So schools have always been a good point for this. And so we've made it very clear that persons who report mandatorily, like who are forced to report, they have no real consequences in terms of breaching their capacity to be professionals. And I think that's important because, you know, it is very important to a doctor, it's very important to a lawyer, but I think people also want to feel good about themselves, and so you want people to want to report. And so that is why these protections are built in. The other point that should be known here, though, is that if a report is of critical importance to the court in terms of proceedings, and the court determines that it is critical to the proceedings, then the person may not be granted leave, because there are some cases where the judge may say you have to come and give this particular information. But I suspect that the judge, as is the case now, will use his discretion. I think one of the things that I have found remarkable in this present conversation is that it is almost as if we think the courts in Barbados will suddenly assume a new personality, and that discretion that has always existed in the court no longer exists. Or that if we say a penalty is $100,000 or 10 years in prison, that everybody is going to get $100,000 or 10 years in prison if you're the perpetrator. You know, when you see that in legislation, it normally means up to a maximum of, and then the judges and the magistrates will use their discretion. That has always been the way that the law has operated. So the reality is that we've put in place a lot of safeguards, but beyond that, I think what is more important is not even the safeguards. What is more important is the relationship with these persons who have to report. They have to have the trust. We have to put ourselves in a position as the Child Protection Authority that they trust us to handle this information. And more importantly, they have to believe that the children, when they make these reports, will be better off for their reporting. Because if nothing happens, then there will be no point to it. So I think it places the onus on us to perform more effectively in protecting children. And at the end of the day, Lisa, regardless of what I'm hearing, at the end of the day, my primary focus is protecting children in this bill.
Sections 28 to 31 deal with investigation, assessment, and action taken by the director, decision against taking action, and removal of the child by the director of the Child Protection Authority. So clearly, the director of this authority, which will be established, has A lot of power.
The director currently has a lot of power. The director of the Child Care Board, if you look at the legislation, currently has a lot of power. But I will say this to you. If you look at most of the powers here, they are done effectively through the court. So that the director does not have unlimited power. The director must get an order, and that the orders are issued by the court. So that for most of these actions require either the court to give an emergency order, it requires the court to give an assessment order, a care order, a custody care order, all these things. At the end of the day, you have to go to court. So while it looks like the director has unlimited power, there are lots of checks and balances because the director has to go to court. And then you have to convince the court that your course of action is the best course of action. Of course, if you also look at the reporting properly as well, you would see that there are also points where the director has to present information to the parents. You know, you've done a report, this is what we found on you if you're the perpetrator, or this is what we found on the perpetrator based on the report. In this law, they have to provide within, I think, 7 days, a copy of the report to the parent. They have to furnish all the things they plan to use as evidence once it gets to court. So there are a number of things in here that offer themselves as checks and balances on the director as well. There are instances where a director can remove a child. Currently in the Child Care Board Act, the Child Care Board Act says that, because people are quoting the Child Care Board Act and saying that it mentions parental rights. It says, yes, parental rights and duties are essentially that of a parent. But then the next paragraph says that the Child Care Board can assume those parental rights. You understand? So the Child Care Board can act as parent. In this particular legislation, all the things that we do must go through the court. Now, there may be instances, and if you speak to a child care officer, now there are times where you may have an ex parte order or an order after the fact. But in this legislation, the director must apply within 24 hours of acting to the court for that emergency order. And why is that necessary? Let me explain it. You may have a situation where a case of abuse is so egregious, so heinous, so horrible to Barbadian sensitivities, or just horrible in general. So horrible that the director must act now.
Yes.
And I'm a realist. And a lot of people are talking have never dealt with children. I'm a realist. There are cases in this country that I know of where children's little bodies are violated to the extent where you have no choice but to act immediately to remove that child from that situation. They're not always the case, but they're those cases. The director has the authority to remove that child if it is in the best interest of the child. People have asked me who determines the best interest. The director still has to go to court. The court then has to agree that removing that child, even in the case of an emergency, was in the best interest. If not, the child goes back. So the court essentially will determine what's best interest. But at the end of the day, there are some cases where you have to remove. I'm thinking now, I won't say it, but I'm thinking now of a particular young girl who I'm visualizing right now, who carries a scar from the top of her vagina all past her navel, all through her stomach. And why? Because her father decided that her little body was his playground. And what do you do in those circumstances? You understand? There may be a case where you have no choice but to remove that child for the child's best interest. And there are many cases where children are beaten so badly that you have to remove them in their own interest. And then once that is done, within 24 hours, however, in this legislation, you have to apply for an emergency order. Now, there are other circumstances that are not so urgent. And when they're not that urgent, if you go through the care orders between 33 and 50, if you go through those care orders, it's listed very carefully. You can have an assessment order, a supervision order, you can have a care order where the director sets out a care plan. The care plan has to go to court. The court has to agree with the plan. These are all new things, limiting the power of the Child Protection Authority, but making it clear how we're going to protect the child. Then and only then, after all these things have failed, read the legislation. Then and only then, when all these things have failed, when efforts to relate to the parent, are past being saved, it's very clear. Then you may apply for a custody care order. And a custody care order then allows the child to permanently come into care. But that is a last resort. And every effort is made throughout this bill to keep families together, to keep children with their parents where it is in the best interest of the child. Many children are abused by the people who should be looking after them. And I want Barbadians to remember that. So, it's not the average parent whose child is even potentially going to be taken in for care and protection. It is a case where something has happened and the child needs to be cared for.
So that the viewing public and those listening can keep up with us, we're actually in part 4 of the legislation.
Okay.
And we're dealing with the care and protection orders. Section 46 deals with counseling and treatment,
Which is essential. If you come to an institution, and you're in need of help, then you should be able to get that help in that institution. The Child Protection Authority, the current Child Care Board, is involved in a lot of this. There's a psychologist assigned to the Child Care Board.
Yes.
In my definition of the 5 Ps, paramountcy, protection, prevention, partnership, and what was the last one, Lisa? Were you paying attention? Paramountcy, protection, prevention, parental responsibility, that was the last one. All of which are important in the child protection legislation. Huh? So when you come to this, partnership is essential. We work with Parados to work with parents. We work with many of the Christian associations in relation to parents. The evangelical associations, other associations. We work with private people who want to come in and do work, so that the capacity to be able to counsel a child is critical. Again, and if you read the legislation very carefully, and I encourage Barbadians to take a look, counseling also for the family, counseling also for the parent, so that you do what you can do to make sure that the child is safe, so that the counseling doesn't only begin and end with the child. The counseling also extends to the parent. The counseling goes on to the family, and I think that's going to be very important. And other cases, the counseling may be for persons the child deem are important to that child. And why wouldn't you want to have counseling? I must also tell you, I know this is not the bill for it, and this is not the place for it necessarily, but once you've been dealing with this kind of work for so long, like many of my officers, sometimes there might be a need for support for the staff too. And we have to put in place in welfare, in childcare, in National Assistance Board, in Disabilities Unit, systems to be able to support the staff too, because this is difficult work.
Minister, Part 5 of the bill deals with childcare centers and covers the principles guiding the operation of childcare centers, foster care, and approved childcare centers, etc.
Well, the legislation defines what a childcare center is, and essentially that is a place where a child is cared for. A place assumed by the state, related to the state, and approved by the minister as a childcare center. And the legislation is very clear. It's an assessment center. It could be foster care. It could be a children's home, a residential center, a secure treatment facility, which is in Section 33, and I think very important, and perhaps if you would allow me, I could talk about that, or a training center. So the legislation is very clear about what is a care center. But also, more importantly, I think it is also important to note that the legislation also makes it very clear that the centers do not have the same authority as the director of the Child Care Board, or the authority. So that some of the things that you see apply to the authority and the director, when you become a delegated person with responsibility for the children, you don't have that level of authority. So people cannot do these things in the Child Care Board homes. They cannot do them in the foster care, all these things. If you want to do anything, you have to come through the director, of course, unless it's something minor. In relation to Section 33, because this is important, in the current bill, the current reality of things, we used to, in Barbados, treat children who were wandering as criminals. We criminalized children. And if you left your home and you were said by your mother or father to be wandering, when I was a boy, the common thing was, if you start talking to a boy, I can put you in Somerville.
Yes.
That was standard. We knew that. And persons were put into a facility, a criminal facility, regrettably, for all kinds of reasons. The new legislation scraps that, but the truth is the court struck it down anyway. What we're saying now is that there may be cases where a child might be in need of some help, however, but not criminalizing that child. So there are two instances. If it's a child who would normally have come into contact with the justice system who's under 12, because in Barbados you cannot be held criminally liable under 12, then instead of leaving this child with no assistance, that child may be brought into this facility. It is not DOTS. It is not government industrial schools. It is a facility for care and protection of children. So a child under 12 who would have done something that needs help will be brought into that facility to be treated. In the current administration, a child under 12 is kind of like a lacuna in the law. And in any event, if you were between 12 and 18, then the minimum sentence you got was 3 years at one of these institutions. The maximum time that, and it's not a sentence, the maximum time that you can get in one of these facilities now is 3 years. And that every 90 days, the Child Care Board must go to court and explain the status of that child to prevent a child from being lost away in the system. It is a facility that will help treat children. It will make sure that they are safe. It will take care of their best interests. And for children under 12, it gives them an opportunity. We spoke earlier about rehabilitation. So it gives them an opportunity for rehabilitation. I think the secure treatment facility is a vast improvement in terms of what currently exists. In fact, if I'm being honest again, I think the legislation is filled with a number of things that are a vast improvement for children. But that particular center is important. And again, you can only get there via the court. So in relation to that, I think that the assessment center, the foster home, the children's home, the residential facility, and so on, all these facilities, the director, and when I say director, it means a director or a person designated by the director, would have to be monitoring them now to make sure that they keep the standard that we anticipate should be kept now in this new child protection facility.
Now, Section 59 of the bill deals with corporal punishment in child care centers, but I want to go outside of that. You have already gone on record as saying that government has no plans of making corporal punishment illegal.
This legislation does not make corporal punishment illegal. This legislation does not make corporal punishment illegal. I've heard people say so. This legislation does not make corporal punishment illegal. The current reality is that at the Child Care Board, in any of our centers or their nurseries, the residential centers or their nurseries, corporal punishment is not allowed. It is unlawful. This legislation carries that over. So within our institutions, it is still unlawful. However, the wider public in Barbados must know that the laws of Barbados outside of this permit corporal punishment. Where it becomes a problem is where that corporal punishment is administered in a way that does severe harm to the child. Now, some people have looked at the definitions and said, well, looking at the definition, it means that I cannot punish my child. And I think the reason for that is because we've listed them very carefully. But verbal abuse has always, you Google it again, Google verbal abuse of a child. It will tell you that yelling, shouting, screaming at a child is abuse. If you look at the definition of physical abuse, it will tell you that hitting and so on is abuse. I feel that then the legislation makes it clear that the director has to go and assess, determine whether or not abuse actually occurred in the household or not. And then it still has to go to court. So there are all these levels of intervention. So corporal punishment is not outlawed. But as I said already, I am not tied, my ego is not tied to anything in this bill. So if it is that in further conversation, there's a need for further clarity, because this point is too important. If there is a need for further clarity around that, we're prepared to have it. That is why we're going to select committee and determine if we need to change the wording or not. Or it might be determined that it is clear enough. However, the definitions that are here are the internationally accepted definitions. They are the same definitions that have guided the Child Care Board for all this time. And corporal punishment in Barbados is allowed. Abuse is not allowed. That is the reality. My personal position is this, that the country needs to have a conversation around corporal punishment. That the country needs to have a conversation about determining, are there other ways to discipline my child? But that is the parent's choice. The law makes it very clear that parents have their own rights and parents have responsibilities. That is the choice of the parent. There is no Barbadian. I have 2 children. There is no Barbadian that can tell me they've never been a point where they had to shout at a child. I mean, even with the patience of Job, sometimes you shout at a child. But only an unreasonable person would assume that that's abuse. And every law, Lisa, must stand the test of reasonableness. Is it reasonable in these circumstances? But we go on later on in the bill to speak about causing harm. But like I said, because it has caused such conversation, I think it is something that we will take another look at. And if there is a need to change the wording, then I'm not opposed to it. It doesn't change the substance of this legislation. And my point here is, at the end of the day, have we created something that is better than what currently exists? And does it protect the children better than the children are currently protected?
No, I went through the bill at least twice, and it is an extensive piece
It's
of
extensive.
legislation.
Yeah.
However, throughout the bill, many times we see the rights of children.
Yes.
What about the rights of parents? And this is also a concern.
Well, if you go through the bill, and you've been through it twice.
I have.
I've been through it 200 times. If you go through the bill, and Lisa, I want to commend you because clearly you've done your homework thoroughly on this bill. But looking at this bill, we do protect the children. It's a child protection bill.
Of course.
But it is also clear that in the 5 principles, the parental rights and parental responsibilities, one of my pieces, very important as well. You know, I did a simple search. How many times is the word parent mentioned in this particular bill? 98 times, in different ways, not all relating to whether the parent should or should not do something. In the other legislation, 20-something times, 16 times. How many times is the word family mentioned in this legislation? I think I got 23 or 24 times. In the current Child Care Board Act, 0 times. The Prevention of Cruelty to Children Act, 0 times. This bill has in it a lot more protections for parents. And when I hear people say, oh, you've taken away the rights of parents, that assumes something currently exists and that we're taking it away. If the law currently does not allow the parent to do something, we haven't taken it away. If you're saying that against an ideal situation in somebody else's mind, then maybe. But in the current situation, the current law, this offers. I sent somebody a message. Can I go to my phone?
Sure.
I sent someone a message because we were having this conversation. And we were looking at parental rights. And I was saying, if you look at this legislation, there are so many points in this legislation that address the rights of parents. Section, I will only go through some because there are too many. The word parent, I said, is mentioned several times. Section 4, a child may, 4F2, a child may retain relationship with parents. Section 7.3, participation of a child at anything that has significant impact on that child's life must include the parent. Section 9.1, the duties of the board include facilitating contact between a child and his parent. Section 9.3, in looking at best interests, the court must consider the ability of the parent to facilitate and encourage a close relationship with the child and the other parent or both parents. Section 22, the removal of a child shall only occur where it is necessary to protect the child from risk of serious harm. Only where it is at the risk of serious harm. And then we go on to say at 23.1, a person may seek assistance in the form of an intervention of somebody else. Again, where the welfare of the child is in jeopardy. So it's only in those cases that you have to wonder as a parent, you know, what is going to happen to in my particular situation. But the issue of intervention, all through this bill, when I go to the orders, if you go through the orders, everything have to go through with the parent. I don't want to go through all these, but if you go through the bill, it is very clear that there is no point at which we keep the parent out of the conversation if it is that it is in the best interest of the child. Do not forget that most of the cases of abuse of a child are by the people who should care for that child. So it's not always going to be in the child's best interest to have a relationship with a parent, but we go through the bill. So the rights of the parents exist. I've also said to you that in the current legislation, when you look at the Child Care Board Act, the only mention after the board takes responsibility is that it says for administering punishment, the rights of the teacher or a parent will not be deemed to have been taken away. This bill is much clearer. And I am amazed, honestly, I am amazed when people say that this bill takes away the rights of parents. Mind you, that this only comes into being where a child has been deemed to be in need of care and protection. So that leaves out significant portions of the Barbadian population. Even then, after that has been determined, even then, the child still has a responsibility or right, if it so desires, to have a relationship with its parent. The current legislation says that after 12 months, if in a child care institution, the parent is hard to find or has abandoned the child, it is deemed by law to have abandoned the child. And the Child Care Board takes authority for that child. That's the current legislation. And I must also tell you, because I live in the real world, that there are many children who are currently in care, whose parents do not look at them at all. They've been brought into care and either by a court order to take the child through the Supreme Court adjudicature, so a permanent arrangement, or by volunteering to have the child. And they don't come to see their children. So I live in the real world. And it is in relation to those cases. But even then, this legislation says no. Go and try to form a relationship with that child. The current legislation says the court, if it's in the best interest of that child, this current legislation, not the one that I'm bringing, the Child Care Board Act regulations. If it is in the best interest of the child, then the court would allow the child to go back to parents. So best interest has always been a principle. I've seen people ask me, what do you mean by best interest? Best interest is already in the 1985 regulations, the 1985 law. So it says if it is in the interest of a child, if it's in the best interest of a child. I have no doubt that there are many things here that are good for parents, Lisa.
Since we're on the discussion of rights of parents, now those children who are wards of the state, the Child Care Board acts as their parent. There has been some concern, however, when it comes to those children seeking medical treatment. What are some of the concerns that you've heard?
So I think the concern emanated from the definition of care responsibility. And care responsibility only comes into being where a child becomes, we don't use the word ward of state necessarily, but where a child is now under the care of the state. And why is there a concern? The current legislation says that care responsibility means the authority to consent to the medical treatment not involving surgery for the child on the advice of a medical practitioner. And at B, it says consent to the medical treatment involving surgery that a medical practitioner certifies in writing needs to be carried out as a matter of urgency and in the best interest of the child. Now, this is where a doctor has determined that this child that is in care needs particular attention. Lisa, there are cases, and this is the most alarming thing that I've seen. There are cases where children could come into care so broken that they need medical intervention. You know, also as a parent, if you have assumed the role of the child's best interest, there could be a case where a child may need to have a surgery. You could fall and break your foot. When I was 16 years old, I played football. I broke my ankle. My mother agreed for me to have surgery. You must appreciate that in these circumstances, the state is acting as what is in the best interest of the child. It still has to go to court. The determination still has to be made by the court. If it is an emergency, we still have to apply within 24 hours. But there are some cases where children need medical intervention. There are some cases where it is so urgent that a doctor may say this child needs to have an operation. No. The Child Protection Authority must act in the best interest of that child with the court. So it is not a case where you just randomly determine what you're going to do. You randomly determine that you're going to give this child something that is not in the child's best interest. What I heard, and I heard a number of things, but that there could be operations that children will regret and so on. That's not the case. It is a case where a doctor, and we have to agree that we trust our doctors to a point, makes a determination that this thing might be urgent. Then the court also has to approve it. If it is an emergency, then the director has to act. But those are cases where, because it's a Child Protection Authority, a child's life could be in danger for things that are so heinous that the Child Care Board has to act, that the Child Protection Authority has to act. That happens now. If you speak to any director of the Child Care Board, the current one, you speak to the former directors of the Child Care Board, they would tell you that they've had instances where they had to take children to the doctor and take the advice of the doctor. There is now this belief, and I do not know where it is coming from, but there is now this belief that something that has existed in our legislation for all this time, that has served to protect children, will now be used to harm children. It is an error. It is not factual. It is conjecture. And I think in the long run, it does more harm than it does good. If, and I'm telling you this not only as the minister, but as a father, there is no way that this government, that myself as a minister, that myself as a father would sit back and allow anything harmful to happen to a child. But the legislation itself does not even suggest it. So these associations are being made by somebody somewhere for whatever reason, but it is not here. And the Child Care Board has always acted in the best interest of the child, and this legislation will do the same thing.
Minister, we cannot possibly get through every section, as I said at the beginning of the program. However, You have said it is not a perfect bill. You
No.
have also listened to some of the feedback, and you are open to making changes if necessary.
Of course. That is why we had consultations before, and that is why we're going to select committee. Select committee will invite people to submit, they'll invite people to come. I mean, the Clerk of Parliament will determine how he wants the information, but it's going to be a conversation. I think that though I don't think the bill, or any bill, any law is perfect, I think this is a very good piece of legislation. I think it addresses the issues that I said were important. I think it protects children. I think it gives good support to the court because the court is limited. I think anyone can feel satisfied that we have a modern piece of legislation that will make Barbados proud, that will protect our children, that makes the administration of it easier. And then lastly, Lisa, I know when you do something right. I used to teach social policy. There is this thing called participatory research. In participatory research, how do you determine if something is true or not? Essentially, it is by what the participants tell you is their reality. The number of people that have stopped me along the road, in the supermarkets, in my car, in and out of this building, everywhere. Number of people, particularly women, but some men, I just received an email, and said to me, keep on fighting, because nobody took us seriously before. Keep on fighting. That this legislation is important to them because they were abused as children. Keep on fighting. Now, I know this is a good piece of legislation. I am thankful for all the conversation around it, even the negative ones, because it has allowed us to have this conversation. But I am protecting children in this legislation. So if people are going to jump up and down in relation to this, then prepare to get healthy, because we're coming and we're delivering on behalf of the people and the children.
Minister, thank you so much for your time.
Thank you too.
And your frank conversation.
Thank you very much.
You're welcome. That was the Minister of People Empowerment and Elder Affairs, the Honorable Kirk Humphrey. I'm Lisa Lord. You are watching One on One. Do have yourself a wonderful evening.
Thank you.